Hello everybody and welcome to Legal Studies Unit 4, Area of Study 2, Law Reform Part 5. The focus of today's video will be dot points 6 and 8, the role of one parliamentary committee or one royal commission and its ability to influence law reform, and the ability of Parliament and the courts to respond to the need for law reform. Let's begin by looking at what a parliamentary committee actually is. Parliamentary committees are used by both the Victorian and Commonwealth parliaments to investigate legal, social and political issues and concerns and report back to the Parliament about the need for law reform. Most members of Parliament serve on parliamentary committees. These committees are usually made up of about 6 to 10 government and non-government members of Parliament. Committees are an important part of the parliamentary system as they allow members of Parliament to examine and evaluate the need for law reform and to receive input from the community. Now we will look at some of the strengths and some of the weaknesses of parliamentary committees. One of the strengths of a parliamentary committee is that it can investigate a wide range of legal, social and political issues and concerns and can report back to the Parliament about the need for law reform. Parliamentary committees can examine issues more efficiently than having the entire Parliament involved in the investigation. Parliamentary committees allow members of Parliament to be involved in investigations and gain knowledge, expertise and understanding in the area of law reform that is suggested. And they also allow members of the community to give input into the issues being investigated. Some of the weaknesses, however, are that parliamentary committees cost a lot of money, meaning that they cannot be formed for every single issue. There is also a time commitment which may deter members of Parliament from sitting on committees. Members of the governing party may actually dominate the composition of the committee because, of course, they have more seats in Parliament, meaning that they sort of have more of a say over what the committee recommends. And lastly, the Parliament does not have to implement the recommendations made by the committee. And this is the same for the Victorian Law Reform Commission. Their recommendations don't need to be implemented either. So that is a similarity between the VLRC and parliamentary committees. We are now going to look at the ability of Parliament to respond to the need for law reform. So Parliament has the ability to respond to law reform because it is an elected body with supreme lawmaking powers. Parliament has extensive powers to make and change laws on behalf of the people. So Section 7 and 24 of the Australian Constitution actually states that members of Parliament must be directly chosen by the people, and this ensures that we have a representative government and the majority of views are being represented. Anyway, aside from that, Parliament has the ability to thoroughly investigate the need for change in law, and this is through parliamentary committees, and they can also respond quickly to the needs and demands of the community. Looking at some of the strengths and weaknesses of Parliament. So as we said before, Parliament is an elected supreme lawmaking body with the powers to make and change laws. Parliament can make and change laws as the need arises to reflect a changing society. And Parliament can abrogate common law, except for decisions made by the High Court in relation to constitutional matters. Some of the weaknesses, however, of Parliament include that they cannot change law if the law is outside of their jurisdiction. Also, members of Parliament may be reluctant to legislate in areas that conflict with community views because they don't want to lose voter support. So we have to remember that members of Parliament want to be re-elected, so they're less likely to make laws about issues that conflict with the views and values of their constituents because they may fear electoral backlash. So that's important to note. And another weakness is that reforming the law can be time-consuming, expensive, and Parliament has limited sitting days. They don't sit every single day of the year. We are now going to look at the court's ability to respond to the need for law reform. So the courts can make law in cases where there is no current law to interpret the meaning of legislation. The courts can make independent judgments and decisions without fear of losing electoral voter support. This is because judges are not elected like members of Parliament are. The courts can also highlight problems, raising community awareness about the need for laws to be changed. However, judges in superior courts may be reluctant to change the law, preferring to leave lawmaking to Parliament, given that Parliament is the supreme lawmaking body. The courts are also restricted to only making laws when a case comes before them. The courts also rely on parties being willing and financially able to pursue a case, and some judges adopt a more conservative rather than activist approach and more narrowly interpret legislation in cases where the decisions will lead to major or controversial changes in law. That concludes today's video. I hope that your knowledge of dot points 6 and 8 from Unit 4 Area of Study 2 have been consolidated. As always, if you do have any questions, feel free to leave them in the comments below. If you haven't already subscribed to my channel, please do so to be informed about future uploads. Thank you.